what's your name?
Aisha Pope.
All right. All right, Ms. Pope. I apologize. I thought you were Miss Clark. Case number is 245521701, ma'am. You have an attorney. Go ahead, counsel.
Good afternoon, man. Please, this honorable court, Larry Polk on behalf of Aisha Pope, who is present by way of Zoom. At this time, we waive the formal reading of the warning complaint. My client stands mute.
Thank you. And Ms. Pope, I have her listed as Nicole Harris, Janetta Ayan Freeman, Elise Luvinia Stewart, and Elise Stewart. I'm going to enter plea of not guilty. Court dates are January 23rd, 2024, probable cause conference. By preliminary examination, January 30th, 2024. Both matters are in front of Judge Giles. Ms. Pope, there are some bond conditions. One is you're not to have any contact with Tanika Lamar Eggleston. You are not to go to the location of 17 City, Detroit. You're not to possess any firearms or any ammunition. Do you understand all those bond conditions, ma'am?
Yes, ma'am.
Okay. All right. Counsel Vincent, I do have prior convictions. She has a prior felony firearm conviction. She has armed robbery 2013, 1992 larceny in a building. I don't have a capious history, and I see that she has Detroit ties. Go ahead, Esteban, please.
Yeah, Judge, on that weapons felony firearms charge, that would be a straight 5 years because the second notice. She's a HAB 4, but a HAB 4 25-year minimum. And Judge, I think yourself, and I'm sure Mr. Polk knows the offenses that this defendant's being charged with. That top one, the assault with intent to rob, being a life offense. And, you know, here we have an individual who was picked out of a double blind lineup. Allegedly, the incident was captured on Ring video. And just to touch on the allegations here, I mean, this is premeditated. We have a gal who ends up bringing flowers, pretending to bring flowers to an individual. Individual opens the door, accepts those flowers, passes those flowers off, and then we have defendant here who brandishes a firearm, trying to rob that individual. So the whole thing was a setup. She's telling the individual to get to the ground. That individual instead gets into a physical altercation with this complainant, trying to get that gun from her, does get the gun from her. And then what happens? We have another individual who comes with a gun, pointing it at the complainant, who had already had a gun pointed at him by this defendant. And but for the firearm that the complainant ended up wrestling from this defendant, that didn't work because the complainant admittedly had said that he tried to fire at that second individual. The gun didn't work. He got back into his house, called the police, and we're here today. I mean, Judge, this is highly assaultive. This is highly dangerous, premeditated, fourth HAB notice, defendant's ID'd. Not much going for this defendant right now. So respectfully, we're going to be asking for $100,000 cash. If the defendant were to post, we're going to be asking for a tether house arrest. In no way, shape, or form is this a flight risk issue. I respect Mr. Polk. Defendant's lucky to have an attorney like that involved in this. This has nothing to do with flight risk. This is purely a danger argument, and we find this defendant highly dangerous.
Thank you. Go ahead, Counsel Polk.
Judges, I would begin that my client does have community ties. She has retained counsel. She is a resident, lifelong resident of the area. She is currently employed. She has some serious medical problems that need to be addressed. She had a doctor's appointment just on Friday. She is unfortunately dealing with the loss of her father, most recently, and within the last year, the loss of her son, her 13-year-old son, who unfortunately passed in a drowning accident. I don't have the benefit of the allegations, and so right now they're just allegations. I don't know about what's allegedly captured on video or any of the circumstances surrounding the allegations. The allegations, my client is not a flight risk. She absolutely will be available each and every time there is court to address whatever needs to be addressed. I'm asking the court to consider something of $50,000, 10%. And of course, the tether is not an issue.
Thank you. I've heard the representations of both sides in this particular matter. I had the benefit of reading the investigative report, in which it does appear your client was positively identified as a person who was involved in the situation. And partial of the incident was caught on camera or video. Let's see. Yeah. And what gets me is the court starts off with a personal bond, but when court starts hearing representations and looking at the investigative report for more information, then the court, if it's entertaining a monetary bond, court needs to use a clear and convincing evidence standard. And what the court read and heard representations during the probable cause hearing is that your client had a firearm, knocked on the door where Mr. Eggleston was. He was told from your client, that flowers were from the complainant's sister, okay? And as he took the flowers to give it to his wife, who was in the house, okay, allegedly your client pulled out a firearm. And at that point, at some point, there's a struggle between the complainant and the defendant. In this matter, the gun was wrestled away from your client, and they're wrestling outside, I believe, somewhere either sidewalk or the front yard. Another individual comes up, a black male who hasn't been identified, indicated that what's going on. The complaint indicates what had happened, and that unknown person pulls out a firearm, okay? And the firearm that the complainant has is the one that he took from Miss Pope. Points to, so both this unknown black male and the complainant are pointing firearms at each other. The complainant retrieves to his home. Police are called. The gun, I believe, is turned over to the police. And it all started with your client. So the court does believe that your client is a danger. Okay. Then she also had the prior conviction of armed robbery, 2013, which is less than 10 years ago, 10 or 11 years ago in this particular matter. So in this matter, her bond is going to be $100,000 cash, no surety, no 10%. Okay. She's also going to have a GPS tether, home arrest. I will also indicate, even though with a home arrest, it is except for medical appointments. And Council folks, just so I understand, this is going to be an unaffordable bond. Is that correct?
That is correct.
Okay. Then she's going to have a court date this coming Wednesday, January 17th, 9 o'clock, in front of Judge McConicle, who will review the bond amount and bond conditions.
Okay.
Okay? Thank you.
Thank you.
What's your name, sir?
Brent Gilbert. Oh, Brent E. Gilbert. Good afternoon.
Gilbert, this is Magistrate Echartea here in a criminal matter. Case number is 240552161. You have an attorney. Go ahead, counsel.
Good afternoon, Your Honor. Kashava Kirkland on behalf of Mr. Cooper, who has been advised of his rights, which is to stand mute and waive the formal reading.
This is Gilbert. Cooper's going last.
Oh, I'm sorry. Good afternoon, Your Honor. Kashava Kirkland on behalf of Mr. Gilbert, who has been advised of his rights, which is to stand mute and waive the formal reading.
I'm gonna enter plea of not guilty. Court dates are January 23rd, 2024, probable cause conference, followed by preliminary examination, January 30, 2024. Both matters are in front of Judge Giles. Mr. Gilbert, while this case is pending, you're not to possess any illegal controlled substances. Do you understand that?
Yes, ma'am.
With that
Yes,
being
ma'am.
said, for both attorneys, I don't have the charges non-assaultive. I don't have cases for criminal history. He has local ties. Counsel Vincent, go ahead, Esteban.
Judge, first off, I'm going to argue the fact that, sometimes these high personal bonds mean nothing. This defendant is on a high personal bond right now on an ongoing case. He has 6 counts in that case, 3 of which are controlled substances, 3 are firearms. One of the controlled substances is 50 to 449 grams. Has to do with fentanyl. He was given a $125,000 personal bond about a month ago. He's scheduled for an exam later this month. Now, Judge, we have this matter before you today that happened at the same residence, allegedly, as that other case where the police ended up raiding the defendant's home, finding the firearms, finding all of the controlled substances. And now, because he was given a personal bond, he goes back to his residence and he does the same thing that he was doing before, selling drugs, fentanyl, crack, cocaine. Judge, we're going to be asking for a $25,000 cash bond here. We're also going to be asking for a tether and house arrest. Personal bond doesn't work. House arrest isn't going to work because we're just going to be putting him back to his place of employment. The only way to protect the community here, Judge, is a cash bond. If he were to post, we would be asking for that monitorization as well as house arrest.
So, Counsel Vincent, let me ask you this. Okay, has there since his last case, okay, has there been any instance where he's not shown up for court?
There was only one hearing and it was a PCC and that's Zoom.
Okay, so there's nothing to indicate that he is a flight risk in this particular matter. Okay, so the only thing is dealing with the drugs and supposedly it is at his home, correct?
Yeah, both instances were at his home, Judge.
Okay, thank you. Counsel Kirkland, go ahead.
Thank you, Your Honor. We're asking for a personal bond in this case. This is non-assaultive. He has no prior convictions, not currently on probation or parole. It does appear that he does have a case pending that he was arraigned, it sounds like a month ago, with similar charges, but those are non-assaultive charges. I don't believe he's a risk. I don't think he's a risk of flight. He's 19 years old, has strong ties to the community, has a child on the way. There's no amount of bond he can afford to post. So he definitely, there's no amount that he can pay to leave the state. I don't believe that he's a danger to the community. I understand, well to begin, these charges are non-assaultive. I understand the court's concern when it comes to having 2 charges of the same. I'd ask that if the court has, I ask the court that these are allegations. I would ask that the court just allow him to, he is presumed innocent, that the court allow him to fight these charges from outside. He's not a risk of flight. He's not a danger to the community. He's appeared in court in his last hearing. He has a preliminary examination scheduled. It sounds like he's participating with his attorney. So he's not a risk of flight or a danger to the community. And last point, Your Honor, that the home that he's staying at is like I said, he's 19 years old. It's a house. And he's staying with family. So if this court is still inclined, I just ask that the court, require that he stay at another home if the court is concerned about him staying at that location.
All right, Mr. Gilbert. Another bond condition, you're not to possess any firearms or any other dangerous weapons. You're not station of 8227 Brentwood City, Detroit. Do you understand that?
Yes, ma'am.
Okay. So I'm gonna give you an opportunity, sir. You're not to go back to that location. Your bond is $50,000 personal bond. Nobody has to pay any money for you to get out of jail. If you violate next time, sir, you're gonna be looking at a monetary bond. You understand that?
Okay. Yes, ma'am. Thank you.
Judge, if I may,
What, Vincent?
he was on a personal bond. He's on bond. Everything that
Council
you just told,
Council Vincent, do you have anything new that you want to add?
yeah, he was already told this in his previous case. Everything you
Okay.
just said, he was already told once.
So you telling me, Council Vincent, that he was banned from going to the location?
But Judge, it doesn't matter if it's
No,
that location or
question.
anywhere else.
Council Vincent, again, was he told that he could not go to that location? That's my question.
That, you know what, Judge, that I can't answer you, but regarding the drugs and regarding the guns and all of that, he was told not to do that, and he already violated.
Well, I'll leave that up to the judge to see whether or not how they're gonna violate it. But we're picking up the subject.
Okay, I appreciate it. Thank you, Judge.
Thank you. You step aside, sir.
Black line, say full name, and middle name too.
Akil Lee Marudy.
Marudy, this magistrate at Chazette, you're here in a criminal matter, case numbers 240-552-1501. Sir, you have an attorney. Go ahead, counsel.
Good afternoon, Your Honor. Kashava Kirkland on behalf of Mr. Marudy, who has been advised of his rights, wishes to stand mute and waive the formal reading.
Enter plea of not guilty. Court dates are January 22nd, 2024. Probable cause conference followed by preliminary examination, January 29th, 2024. Both matters are in front of Judge Robbins. Mr. Marudy, while this case is pending, you're not to possess any firearms or any other dangerous weapons. You understand that, sir?
Yes, ma'am.
That being said, to both counsels, the charge is non-assaultive. I don't have a previous history. I don't have a criminal history. And he has local ties. Counsel Vincent, go ahead, Esteban.
Yeah, thanks, Judge. The only other thing I have here, and I think it was mentioned in the investigator's report, so I wanted to do a little bit of work into it. I think you saw it as well as defense counsel. There's that bench warrant out of Farmington. In the investigator's report, it says a larceny, kind of, sort of. It's a breaking and entering. There was a complaint that was issued on August 22nd, 2023. I don't think he's ever been arraigned on that. So we have that out there, but we don't have anything else, Judge.
Thank you. Okay, with that being said, Mr. Marudy, take care of your Farmington Hills matter. Do you understand that? Or your Farmington matter?
Yes, Judge.
And with that being said, okay. Breaking and entering, okay. Not knowing if that's assaulted or not, okay. Or involved assaulted factors in this particular matter. I'm gonna give him a $20,000 personal bond. And I believe, Counsel Kirkland, you're not objecting, correct?
No, Your Honor.
All right, Ms. Marudy, you can step aside.
Thank you.
So I got Farmington, see if they want you first. Stand on a black line, say your full name on there
Christopher Livingston.
to them,
Oh, Christopher Livingston.
middle name.
Dion.
Mr. Livingston, this magistrate at Charte, you're here on a criminal matter, case number is 240-552-1901. You have an attorney. Go ahead, counsel.
Good afternoon, Your Honor. Kashava Kirkland on behalf of Mr. Livingston, who has been advised of his rights, wishes to stand mute and waive the formal reading.
Thank you. I'm gonna enter plea of not guilty. Court dates are January 25th, 2024. Probable cause conference followed by preliminary examination, January 31st, 2024. Both matters are in front of Judge Sabri. Mr. Livingston, while this case is pending, bond conditions, there is no assaultive or combative behavior on your part. You're also not to possess any firearms or other dangerous weapons, and you are not to have any contact with a Jordan Thornton. That means no person-to-person contact, no contact with third parties, no phone calls, no emails, no text messaging. You understand all those bond
Okay.
conditions?
Yes, sir. I mean, yes, ma'am. I apologize. Yes,
Thank
sir.
you.
Yes, ma'am.
With that being said, okay, I don't have a case history, but I do have criminal history. Last conviction, 2016, assaulting police officer causing injury. 2015, assaulting police officer. 2014, breaking and entering building with intent. I see also that he lives in the metropolitan area. Go ahead, Esteban, counsel, Vincent.
Yeah, Judge, with all due respect, that have notice really doesn't do justice in terms of the criminal history of this defendant. Going as early back as 05 and 07, he had assault and battery juvenile adjudications. He ends up picking up a conviction for a controlled substance in 2010. In 14, it wasn't one B&E that he was convicted for, it was two. In 2015, he had consecutive DVs and DV second convictions. Then in 16, he had not one, but two counts of R&O and one count of A and B that he was convicted of. In 21, he has a refusal to obey police. He also gets a conviction for trespass. He has an ongoing A and B case out of 36 district where there was a bench warrant issued for $30,000 cash or surety on November of 2022. And then we have this defendant who flicked a cigarette at a police officer apparently in his face.
Well, I'm gonna just be quiet because he's saying like I did it on purpose or something.
Mr. Livingston, just let me represent you. Don't speak.
So the police end up coming out because the defendant's at a gas station, already been asked to leave. Police come out, give him the opportunity. They say leave. And what does he do? How does he reciprocate that? He says he's not going anywhere. And then what does he do? He takes a cigarette he was smoking and flicks it in a police officer's face.
Warner's here.
So,
Okay, thank you.
Judge, we do find him.
Council Kirkland, go ahead.
Thank you, Your Honor.
Did I
Your
even
Honor,
tell
we're
you what I was
asking in
asking
this.
for?
I'm sorry, did I miss something?
No, you didn't. Let me just
Okay.
end it by saying, I apologize, Ms. Kirkland. I'm asking for 100,000 cash. I'm also asking for a tether and house arrest as a direct result of the flight, as well as the dangerous component. Ms. Kirkland, I did not mean to interrupt you or Your Honor.
No worries. Thank you, Your Honor. Your Honor, we're asking for a high personal bond with the GPS tether. He is a lifelong resident of the Detroit area. I do understand. It sounds like I don't know if what we heard were convictions, because I know that 2021 that was mentioned isn't on here. But it sounds like, I mean, he does have some misdemeanor issues. We've had conversations with him and think that there may be some psychological issues as well. At this point, there's no amount of bond that he can afford to pay. There's no amount of bond that he can afford to pay. So if he's given some type of cash bond, Your Honor, he's essentially going to sit there. In addition to that, he says that he's completed college. Like I said, he's a lifelong resident. So we are asking for a personal bond. I don't believe that he's a risk of flight, and any concern that the court has for dangerousness can be cured with the GPS tether.
Thank you. Reviewing the representations of both sides, this particular matter. And what I see is that Mr. Livingston does appear to have a history of violence, whether it's with the police or third parties. And in this particular matter, part of it, when I'm reading from the investigative report, is that not only does it say that Mr. Livingston flicked his cigarette, let me see, flicked his lit cigarette at Thornton's face, but I'm also reading is that he flicked the cigarette in Officer Thornton's eye.
Whoa. So who wrote this report up?
Whoever it is, okay, it appears it shows
That's
that
a miscommunication here, but
he doesn't like to follow orders. He doesn't have any respect with the law enforcement in this particular matter. Okay, and if he doesn't like something, I'm not sure if it's violence is the only way, but there appears to be some history in this matter. He was told to leave the location. He didn't like it. And at some point he got into it with a police officer and flicked a cigarette at the police officer's face or his eye. This court does believe that Mr. Livingston is a danger, okay? And the court has to use clear and convincing evidence as a standard. And by looking at the allegations, as well as the allegations in the investigative report and the history and going forward, we don't believe that Mr. Livingston can control his emotions in this particular matter. So in this particular matter, this bond's gonna be $25,000, cash, no surety, no consent. Okay. As to the GPS tether, I don't have any
Let her finish.
that he is flight risk.
Bullshit with his big sucking ass, man. This nigga wrote
Mr.
this shit
Livingston,
about-
please.
Okay.
Are you fucking serious?
Mr. Livingston.
Your client wants to, doesn't respect this court, by him making a statement, but we're not gonna go with that. And he has already
Mr.
left.
Livingston,
His bond is $25,000 cash, and because it's unaffordable, is that correct, Council Kirkland?
yes, Your Honor.
And he's gonna get another court date for this Wednesday, January 17th, 9 o'clock, in front of Judge McConaughey, who's gonna look at the bond amount and bond conditions. Thank you,
Your
Mr.
Honor.
Livingston. You can step aside.
Thank you. I apologize to both judges, but that nigga retarded, man.
Take a seat in the bullpen. Mr. Lee.
So when we riding up the window,
Yeah, you got it right on.